Okay, thank you all. This is the voting list number 22. It's Thursday, March 28th, 2024, and we're in finance. And we're going to start with Nathan.
So the first thing on the agenda is a concurrence. I think this is the first of the year. So this is Senate Bill 212, which is the cross file for House Bill 1048, Behavioral Health Advisory Council and Commission on Behavioral Healthcare Treatment and Access Alterations. So Senate Bill 212 is the departmental bill that generally requires the Behavioral Health Advisory Council and the Commission on Behavioral Healthcare Treatment and Access to work in conjunction with one another. The bill also alters the membership and terms of the council and requires the commission to make certain recommendations regarding the integration of somatic and behavioral health services in Medicaid. So the House amendments add the Secretary of Age. This isn't on the list. This is a concurrence. Yeah.
Okay.
So the amendments add the Secretary of Aging and a representative of the Maryland States Attorneys Association to the commission. And this aligns the Senate bill with the House bill that passed the Senate yesterday. So a motion to concur would keep the two bills aligned.
Do we have a second?
Senate Bill 212.
Senate Bill 212. I have a motion to concur. Do I have a second? We have a second. All in favor of the motion to concur so that the House bill and Senate bills are in the same posture? No. Where are we? Senator Hayes, are we okay on the concurrence? Okay, thank you.
So the next item would be the blue consent calendar, voting list number 21. There are 4 bills on there, but we'll need to pull off House Bill 1171 for an amendment that arrived this morning. The remaining bills are House Bill 669, which is workers' compensation hearing loss, House Bill 980, which deals with the opioid restitution fund, opioid restitution advisory council and fund, and then finally a bill related to the State Board of Examiners for audiologists, hearing aid dispensers, speech language pathologists, music therapists.
Second for the consent calendar. So Senator Kramer and then Senator Klassmeyer, all in favor of the consent calendar. Thank you, unanimous.
Right, and then next would be House Bill 1171, which was just removed from the consent calendar for an amendment. So this House Bill 1171 is identical to Senate Bill 944, which passed the Senate unanimously earlier this session. The bill repeals a prohibition under the criminal law article against selling a non-latex condom by means of a vending machine, while establishing a prohibition against the sale of a natural membrane condom from a vending machine under the Health General article. So there's an amendment to the bill that excludes the bill's prohibition against the sale of a natural membrane condom through a vending machine from the general penalty provisions under the Food, Drug, and Cosmetics Act. An identical amendment will be added to the Senate bill.
Do I need a motion for the amendment or the amended bill?
You'd move favorable on the bill as favorable with amendments.
Okay. Move favorable on the bill's amendment. Senator Klassmeyer. Senator Ellis, you seconding? Okay, I need a second. Okay, we have a second from Senator Washington. Senator Ellis, your question?
Madam Chair, I'm not sure what I'm voting on. I'm not sure what the difference between these form of condoms are and why it's bad to be in a vending machine or not.
I can
no idea. If I can.
So
Nathan's going to answer your question, but
Yes.
we need to all settle down.
So the bill is the bill that is before the committee, before the amendment that's being offered at the voting session today, is identical to Senate Bill 944, which passed the Senate unanimously. The amendment is clarifying that the bill's prohibition against the sale of a natural membrane condom through a vending machine is not connected to the general penalty provisions that would otherwise be invoked under the Food, Drugs, and Cosmetics Act. So it removes the penalty, but it keeps in place the prohibition.
Okay. On all condom sales with them?
No,
just
only related to the sale of a natural membrane condom from a vending machine. So the Department of Health provided testimony that natural membrane condoms are not as effective at preventing sexually transmitted infections, and that therefore they wanted to keep the prohibition for the sale, prohibition against the sale of natural membrane condoms and
Okay,
vending
well,
machines.
thank you. That makes sense. And I
Great.
don't know why I was tuned out with the Senate bill.
There was just a lot going on.
Thank you, Madam Chair. Thank you.
Okay, so we had a motion and a second on the amended bill House Bill 1171. All in favor of the amended bill? Very good, unanimous. Thank you.
So now it's on to voting list number 22, which is the yellow list. The first bill is House Bill 189, which is identical to Senate Bill 371, which passed the Senate earlier this session. The bill requires each residential service agency to submit a report to the Department of Labor documenting the agency's average wage rate and the highest and lowest wage rates for personal care aides. And the Department of Health must also submit a certain report on ensuring access to a Medicaid final federal rule and the plans or steps the department will take to operationalize that rule. There's one amendment that aligns this bill with Senate Bill 371, moving up from July to June, the effective date. So a motion favorable with amendments would be appropriate to align the two bills.
Move favorable with the alignment.
And second, Senator Washington, all in favor of House Bill 189 as amended? No, let's call roll.
House Bill 189, favorable with amendment. Vice Chair Klausmeier.
Yes.
Yes. Senator Kramer.
Yes.
Yes. Senator Hayes.
No.
Yes. Senator Reedy.
No.
No. Senator Ellis.
Yes.
Yes. Senator Mouts.
No.
No. Senator Washington.
Yes.
No, it's
Yeah.
not a
Senator
crossfire.
Guile.
Yes.
Yes. Senator Lamb.
Yes.
Yes. Madam Chair.
Yes,
Yes.
8-2. Thank you.
So the next bill on the list is House Bill 251. This is an unemployment insurance bill that on the language of the bill is a bit complicated, but the concept is fairly straightforward. So the testimony of the Department of Labor was that an employee of a school system, so like someone who works in the cafeteria, if they are employed by the school, they are not entitled to unemployment insurance benefits during the summer break because they have reasonable assurance of having a job on the other side of that break. During the pandemic, there was a decision within the department's appeals process that applied that prohibition against receiving unemployment insurance during the summer, not only to the employees of, for example, the school system, but also to an employee of a for-profit company that provides those services. So for example, if a school system had a for-profit company under contract to provide those lunch services, the department's position forever before was that those individuals could receive UI benefits during the summer because they did not have the reasonable assurance of a job on the other side of the summer break. So with that decision made at the appellate level for unemployment insurance claims, the department has come back with this bill clarifying that employees of for-profit entities who provide services exclusively for an organization that would otherwise mean the person couldn't get UI benefits during the summer can in fact receive unemployment insurance benefits in the summer.
Senator Reedy, a motion and a second,
Move favorable.
a second, okay. Senator Reedy,
I
Right to
listened
the-
very carefully
Yeah.
to your explanation, and I feel like there's a double negative and it's confusing me.
Okay.
So I work for, Holy Redeemer Church, and I work in one of these roles at this church. And the church has a school, and I am unemployed for 3 months for 2.5 months during the
Right.
summer break.
Yes.
I cannot get unemployment right now,
Yes.
and I
because-
never could, correct?
Correct, because of the reasonable assurance that you still had that job on the other side of the break. The difference is that if you were an employee of a for-profit company that was performing the same services, because that for-profit company could terminate you or reassign you or take any other number of actions, that individual, per the department's interpretation, would be eligible for unemployment insurance benefits.
But if I worked for Holy Redeemer Church, they could fire me in the middle of the summer too, couldn't they?
It's just the difference in the way the law is structured. There's a prohibition in the law that says that an individual who is an employee who has a reasonable assurance of having the job on the other side of the break, that they are
So
prohibited
what-
from receiving
So
UIL.
what this bill does is it doesn't fix it for the employee of Holy Redeemer Church, but if I work for a food contractor that contracts to be the lunch people at
Yes,
Holy Redeemer School,
yes. It fixes-
I cannot get unemployment, but now with this bill, I would be able to.
you could before a decision that was made. So the department's testimony was that during the pandemic era, they hired on people who were able to help adjudicate unemployment insurance claims. A decision was made by one of those adjudicators that an employee of a for-profit company could not receive unemployment insurance benefits and was treating them as an employee of in the example.
And so this bill is seeking to make it
correct that
so
issue.
that,
It is correcting that interpretation that the department feels was erroneous and taking the department back to the position it was in before.
sounds like we've stumbled into a way to save the unemployment insurance some money. I'm not sure why we're changing it back, but okay, thank you.
Any other questions on House Bill 251? We have a motion and a second. Better call the roll.
House Bill 251 favorable, Vice Chair Klaus Meyer.
Yes.
Yes, Senator Kramer.
Yes.
Yes, Senator Hayes. Pass. Senator Reedy.
No.
No. Senator Ellis.
Yes.
Yes. Senator Mount.
No.
No. Senator Washington.
No.
No. Senator Guile.
Yes.
Yes. Senator Lamb.
Yes.
Yes. Senator Hayes.
No.
No. Madam Chair.
Yes.
Yes. 6-4.
Next bill on the list is House Bill 378, which alters the requirements for licensure as a dietitian nutritionist from the State Board of Dietetic Practice. The bill also updates the name of the Certification Board for Nutritional Specialists to be the Board of Certification of Nutrition Specialists, and also updates the name of the American College of Nutrition to be the American Nutrition Association. There are no amendments. There's no fiscal impact, no opposition at the hearing.
Motion on House Bill 37 and a second. Can I have a second on House Bill? Thank you. Senator Klausmeyer and Senator Kramer. All in favor of House Bill 378 that has no fiscal note? Unanimous. Thank you.
Next is House Bill 411, which as amended in the House, requires the Department of Health to submit a report to certain committees of the General Assembly by December 1 each year from 2024 through 2026 on current opioid overdose reversal drugs approved by the FDA and whether the department has added each currently FDA-approved opioid overdose reversal drug to a standing order, and if not, why. There are no amendments before the Finance Committee. There is no fiscal impact.
All in favor of House Bill 411? Senator Hayes, you okay? Unanimous vote.
Next bill on the list is Senate Bill 408, which as amended would be identical to House Bill 411 that the committee just advanced.
Senator Washington, who seconded it? Senator Mounts. All in favor of amended Senate Bill 408?
Next bill is House Bill 757, which authorizes a supervised medical graduate, which is defined as an individual who has a doctor of medicine or a doctor of osteopathy and has passed certain examinations to perform delegated duties in accordance with regulations adopted by the Board of Physicians and under the direct supervision of a delegating physician. The bill also repeals the termination date of provisions authorizing a licensed physician to delegate duties to a registered cardiovascular invasive specialist. There are no amendments, no fiscal impact, no opposition at the committee hearing.
Second.
Senator Hayes motion, Senator Klausmeyer second, all in favor of House Bill 757. Okay, thank you.
House Bill 822 is similar to Senate Bill 790, which passed the Senate unanimously earlier this session. The bill is related to the EID program. The only difference between this bill and Senate Bill 790 is that the House bill includes a study of the fiscal and operational impacts of implementing an EID program that serves individuals 65 and older and establishing a premium contribution for EID program services. Senate Bill 790 will be amended in the House to include that study. So there are no amendments on this bill before the Finance Committee.
Second, all in favor of House Bill 822? Unanimous vote. Thank you.
House Bill 959 alters the continuing education requirement for certified dialysis technicians, requiring 3 hours of continuing education rather than a 3-hour course. There's no amendments, no fiscal impact, no opposition at the hearing.
All in favor of House Bill 959? Unanimous vote. Thank you.
The next bill is House Bill 1053, which removes the requirement that the executive director of the State Board of Nursing must be a registered nurse. The bill takes effect following the termination of provisions under current law that give the Secretary of Health the authority over the infrastructure operations of the board. So essentially, the bill would take effect July 1, 2025. There's no amendments, no fiscal impact.
Senator Washington and Senator Reedy, were you the second? Okay, all in favor of House Bill 1053? Unanimous vote. Thank you. Senator Lamb, you're opposed? Is that the only opposition? 9-1. Thank you.
The next bill is House Bill 1078, which requires Medicaid to provide remote ultrasound procedures and remote fetal non-stress tests if the patient is in a residence or location other than the office of the patient's provider, and then also and the provider follows the same standard of care that the provider would follow when providing services on site. Medicaid must issue guidance for providers to implement the bill. There are no amendments, no fiscal impact, no opposition at the hearing.
Favorable.
A motion with Senator Classmeyer, second with Senator Gah, all in favor of 1078, House Bill 1078. Unanimous vote. Thank you.
Next is House Bill 1105, which requires an individual to be certified as an advanced practice registered nurse before practicing as an advanced practice registered nurse in the state. So the bill specifies that this requirement does not apply to a student enrolled in a graduate level accreditation program for advanced practice registered nursing, or an individual permitted to practice as an APRN under the rules from the board. There are no amendments, no fiscal impact, no opposition.
I need a minute. I don't understand what you just said.
I can go over it. So basically, the Board of Nursing has said that a provision in the health occupations article, specifically 8301, is insufficiently clear in its authorization for advanced practice registered nursing students to practice as APRNs while they are students, in line with their education, clinical training, and scope of practice. So the bill is just clarifying that generally you cannot be an APRN unless you are an APRN, but that students pursuing APRN certification may do those tasks.
Okay, thank you. A motion for House Bill 1105? You did, and then Senator Ellis was the second. All in favor of House Bill 1105? Thank you.
House Bill 1206 establishes the Maryland-Ireland Trade Commission within the Department of Commerce. No amendments, no fiscal impact.
I'm sorry.
Quickly, do we have any other similar such trade commissions with any other country?
I'm
State?
not aware of any. But that does. So it establishes the Maryland-Ireland Trade Commission within the Department of Commerce to study and promote trade between Maryland and Ireland. The commission must study and make recommendations regarding trade, business, and academic exchange and mutual investment and other policies. It is set to terminate September 30th of 2026.
Can we amend Israel one?
I mean, I like Ireland as much as the next person, but it just seems to me that it's a little bit more in the purview of the federal government, but that's all I'm gonna say.
Realize we had a motion, we didn't have a second before the question. So are we moving unfavorable? We don't have a second, so it's just, you're seconding?
Well.
Okay. No, the motion, there was a favorable motion. We didn't have a second. Senator Mounts just seconded. Okay, I think we need a roll call.
House Bill 1206 favorable,
Yes.
Vice Chair Klausmeyer, yes, Senator Kramer,
Sure, no, you're not.
yes, Senator Hayes,
No.
no, Senator Reedy,
Pass.
pass, Senator Ellis,
I'll pass for now.
pass, Senator Mounts,
Yes.
yes, Senator Washington,
Yes.
yes, Senator Guile.
I'm gonna vote no, but I just wanted to explain my vote. I just like, I just feel like, I mean, we've got a lot of commissions. We've got, I'm all about trade with Ireland, but I'm not sure that this is something additional that we should be doing. And it just opens the door for, let's do an Italy, Maryland Trade Commission, I just feel like it's, so no.
Senator Lamb. Pass.
Yeah.
Senator Reedy,
Yes.
yes, Senator Ellis,
On behalf of the O'Ellises, I think I'll be taking the hard vote. I'll take a lead from my senator. No.
no, Senator Lamb,
How many Irish people are in the rest of the
I think they already have thought. Did the chair vote?
no, Madam Chair,
No.
no,
Whoa.
5-5
5. Bill does not advance.
fails.
Okay. House Bill
Next.
1451.
House Bill 1451, as amended and shown in the reprint, is identical to Senate Bill 764, which passed the Senate unanimously earlier this session. The bill establishes the Arts Incubator Work Group.
A second, I have a question.
Shoot. Oops.
So the name, did the name change or was that the name that?
So the amendments to the bill, the amendments alter the title and purpose paragraph and alter the name of the work group, as well as the membership of the work group, aligning the bill with the Senate bill. So
Okay, so the House has already amended the Senate bill to be Jeremy.
I am not aware of amendments being applied to the Senate bill. This is the House bill as it came over from the House.
I thought you said it was identical to the Senate bill.
With so as the Senate bill passed the Senate,
Okay,
which and I can check.
but it's not if the title's different.
I do not have information that the Appropriations Committee has amended the Senate bill to match what they sent over in the House bill. I can look very quickly online to see if there's been any movement on the Senate bill, but the amendments before you return House Bill 1451 to its original state and then apply the same changes to membership.
Just give Nathan a minute. He's
Oh,
looking
sorry,
at
he's
something.
looking.
So
Okay.
the Senate bill 764
Yeah, you can say that again.
was reported. So it says favorable with amendments, in the House, but the amendments are not available yet. So it has not been read for second
I'd like to
reading.
hold the bill.
Okay.
Yeah,
I know. But I'm just confused about, is it in the same posture? Are we gonna be making a bigger problem by accepting this amended bill when the Senate bill maybe wasn't amended? I'm just trying to figure out the process. Okay. So next we have House Bill 1486.
So House Bill House Bill 1486 is as amended and shown in the reprint. House Bill 1486 is identical to Senate Bill 816, which passed the Senate unanimously earlier this session. The bill alters requirements related to the Cyber Maryland program and fund. So the amendments require, as was added to the Senate bill, the amendments on the House bill would require the governor to include $250,000 in the annual budget for talent pipeline management.
Do I have a second?
Second. Oh, wait. Second.
I have a motion and a second. All in favor of House Bill 1486? It's a unanimous vote. Thank you. David.
Yes, the first bill on your list, on this, whatever page this is, page 3 of 4, is House Bill 68. It requires, first of all, the bill was vastly amended. If you were, I don't know if you remember, back in January, there was a Senate bill that hearing on Senate Bill 76. There was a lot of opposition. So the week of crossover, the House worked on their bill and came up with a vastly amended bill. And I'll describe what the House bill does as it came out of the House. It requires providers to post the most recent disclosure statement on their website, hold a meeting open to all of the provider subscribers at least quarterly, provide an aggregated de-identified summary of internal grievances at the last quarterly meeting of the year, and provide specified information to a subscriber or the subscriber's beneficiary regarding entrance fee refunds if the refund is conditioned on the reoccupancy of the subscriber's unit. If you recall, the bills introduced had much more details regarding entrance fee requirements and how they were refunded. The Maryland Department of Aging must collect information from providers regarding internal grievances and report on the data received by December 1st each year to the General Assembly. The bill will be prospective and may not be applied or interpreted to have any effect on the application to any cause of action arising before the effective date of the bill. And there's an amendment in front of you from Senator Lim that we got this morning, which if you go to page 4 in line 21, I would call it clarifying or more demonstrative about what you talk about regarding the governing body shall determine whether a matter is confidential. It would be in its sole but reasonable discretion. So it would be clarifying on what the governing body shall determine whether a matter is confidential. And as the bill is amended, there is no opposition. Amended in the House. This is House Bill 68, yes.
Motion, do I have a motion favorable? Move favorable, Senator Reed, and Senator Classmeyer was second. All in favor of House Bill 68? I'm sorry, with the amendment, Are you okay? You want to turn your light off?
Okay.
All in favor of House Bill 68 as amended? Okay, unanimous vote.
Okay, and if you do you want to amend Senator Lamb's Senate Bill 76 to be identical to the House bill?
Would you like that? Okay, so we're going to amend. Do we need to vote on that?
You should. It'd be the
Okay.
same vote, I would.
Can I have a motion to,
Favorable.
okay. So we're making Senate Bill 76 identical to House Bill 68. All in favor? Unanimous vote. Thank you.
The next bill is a departmental bill. It's House Bill 183. The bill, you heard the Senate bill earlier this year, and there was a lot of concern about how this bill was going to be implemented and how it was made to work with the budget. So the Appropriations Committee had the bill over there, and they are also Budget Committee, so they worked everything out. So briefly, the House bill one eighty-three is a department bill that makes technical and clarifying changes to the Summer Supplemental Nutrition Assistance Program, SNAP, for children by removing the requirement that SNAP funds or that supplemental funds be added to a household account within a specified number of days, altering the date by which counties must submit a program application to the department, altering the information participating counties must submit, and altering the dates by which specified information must be provided to participating counties by the department. Summer SNAP funding may be used to provide funds to a county to supplement benefits and offset administrative costs of a federal program. The bill also alters the service obligation for and makes technical and clarifying changes to a pilot program for Human Services Career Scholarship. There was also a mandated appropriation in the bill that was struck by appropriations. So that is the bill that is in front of you, which enables the Department of Human Services to implement Summer SNAP.
Do I have a motion for Summer SNAP? Senator Gile moves favorable. Is there a second?
Second.
Senator Washington moves second. All in favor of House? Yes, you may ask a question.
Because we haven't passed this bill on this side, right? So I'm
No,
not- yeah.
you defer to let the House work out
Right.
the issues.
So you went through a lot. I'm reading through the fiscal note what the current law is. This doesn't add any cost to the system.
It doesn't add any cost. The money from Summer SNAP comes from the federal government. And this just creates a format for them to update their law to implement Summer SNAP and allow these funds to flow through to kids in the summertime. I'm not very much familiar with the Summer SNAP program, but these are, it allows them to implement the program in a manner consistent with the federal funds that are coming down.
So the Fed's made some tweaks and changes and we're just making sure our system.
That's my understanding, yes.
Money basically. Okay,
Yes.
thank you very much.
We had a motion and a second on House Bill 183. All in favor? Unanimous vote. Thank you. He said no.
Okay, the next bill was heard the other day. It's I got my bills out of
House Bill
order here.
253.
Yeah, I got my bills out of order. All right, sorry. Okay, the next bill is an department bill from the Maryland Cannabis Administration. It's a thick bill. You have a reprint in front of you because there was a technical amendment offered by the administration to the House bill. There is no Senate bill. As with any time you create a massive program, there's corrections that have to be made the following year, and that's what this bill is largely corrective. I'll go through it briefly what it does. It's an emergency bill and it clarifies the meaning of cannabis. It codifies existing practice regarding the amount of cannabis a qualifying patient may possess. It repeals specified requirements for the Alcohol, Tobacco, and Cannabis Commission regarding the development of best practices, which are now going to be handled by the Maryland Cannabis Administration. It alters the membership of the Advisory Board on Medical and Adult Use Cannabis and expands its charge. It explicitly authorizes the Cannabis Administration to issue specified penalties after exercising its hearing authority. It alters provisions relating to cannabis processors. It goes up to 1,000 pounds. It goes from 1,000 pounds to 2,000 pounds of processing ability. It extends cannabis registration requirements to cannabis nurseries. So a lot of the pages in this bill deal with establishing a new type of registrant, which is a cannabis nursery. It authorizes the Maryland Cannabis Administration to temporarily register cannabis agents under specified conditions. It alters provisions related to advertising. It transfers the administration of the Cannabis Regulation Enforcement Fund from the Comptroller to the Maryland Cannabis Administration and makes other technical clarifying changes. There were also a few amendments added by the House after they heard the bill. It additionally authorizes the Office of Social Equity to request information from local jurisdictions to reach funds from the Cannabis Reinvestment Fund. It requires the Office of Social Equity to study the impact of possible federal changes to the scheduling of cannabis from a Schedule I drug to a Schedule III drug, if it happens. It expands medical delivery of cannabis another year to July of 2025. It also expands the ability for existing growers to expand their canopy up to a certain level to January of 2027. It also alters background check provisions for to make for current practice, and that's the amendment on page 17 that was offered by the administration over here in the Senate. And they mentioned that at their hearing. So if you go to page 17 in the reprint, you'll see. Okay. If you go to page 17, you'll see that they're altering the background check requirements to conform to what they're currently doing right now. So that in very quickly is what this multi-page bill does, and it largely makes corrections from last year's bill. Hard to believe it wasn't perfect.
I guess we'll just start with questions so we can decide if we're going to vote favorable or unfavorable. Senator Washington, you had the first light.
Thank you, Madam Chair. This isn't that Brian Feltman bill, right?
No, this is
No, I'm
not. That's
joking, I'm joking, I'm
that's
joking, I'm
coming
joking.
up on the list.
I'm joking. I'm
Okay.
The advertising piece, what was the change in here for the advertising? Piece?
The change in the piece was allowing people to use their logo. If the audience is, 85% of illegal age to buy cannabis, they can use their logo for fairs or various expos or something like that. That's yeah.
Got it. Cool. And this is because it increases fines and allows them to do things. I know we did pass that Corey McCray bill. Does this have anything? We didn't pass that Corey McCray bill?
No, you passed the Corey McCray.
But this
bill.
hasn't, this is completely opposite. This is not related.
It's not related to the
Got it.
Corey McCray bill regarding dispensaries and nuisances.
Got it.
No, this is not. This is just mostly corrective. That's new policy that you set with passing the senator's bill.
Thank you very much.
Thank you, Senator Reed.
I'll defer to Senator Hayes first.
Senator Hayes?
Yeah, I hear what you're saying, David, but it's not completely corrective.
No, it's not completely corrective.
Yeah, especially like with the advertising. I think one of the very conscious things that this committee made was like around advertising and stuff like that. This is a complete shift to what we wanted to do among some other things. And I'm sorry, I just don't even remember the hearing, but it's a lot to consume. I'm curious at what the other questions are, but I did want to point out that there's some really substantive departures from policy from where we were.
There is the logo, which the chair can explain. There's also the expansion of the delivery of medical cannabis another year, additional year. And also
I'm sorry, say that part again.
the delivery of medical cannabis.
Oh, one more.
You authorized the extension of last year, you authorized it for up to 2024. This takes it to another year. And also there was a limitation on how big a grower could do regarding canopy. So you were allowing some existing growers last year who had plans to go up to a certain canopy limit to be able to do that,
Right.
even though they may be limited by the laws structured. So this extends that ability for some growers to go beyond that limit another year too.
Right. And one of the reasons why we limit the expansion of delivery of medical cannabis, because the idea was that those micro businesses would come online. Has that been delayed?
The licenses, there were, the micro licenses, there's only 10, and that they're they're in the process of
On
getting
schedule.
licenses, yes.
And so do you know what the justification was in expanding the medical?
Another year, I'm not entirely certain. I'd have to talk to the House and see why they decided to move that up another year.
Because we're not ready for the micro businesses to do delivery, and for some people that this is only medical marijuana. It's the
Right.
only thing.
Yeah,
that's
so
being
it's
delivered.
only medical marijuana
So-
can be delivered.
So, you have people that aren't capable of going and picking up their marijuana because they're at home, they're in pain, they're dealing with cancer, whatever their health issue is. And so this allows delivery to their homes for medical marijuana, not all cannabis. just
No,
medical.
I totally hear you. I think the thought for us around micro is the barriers of entry were lower, and so it gave more opportunity for diverse ownership, especially as it relates, to the micro licenses. And that's why I was asking, are we not ready to see the micro licenses come into effect, and thereby we don't want this to stop because they won't have it. Is that the reason? Okay.
Will said they don't have the micro licenses up and running yet.
Gotcha.
So it's going,
Alright.
we're going to do everything we can to protect the minority business opportunities, but
Correct.
we also don't want.
No, we
people-
don't want
that are
people
sick.
from not getting their medicine as well.
And on the marketing issue, number one, it's limited to where when your audience, 85% of your audience is over the age of 21. So it's very limited, but I'll give you an example.
Oh, yeah.
I have a dispensary in my district and he has multiple dispensaries in other districts, not yours. But he does a lot for the community with our hospital events and our hospice events, the golf tournaments, and he's a big sponsor, serves dinner, the whole thing. At this point, he can't take any credit as his dispensary. So this will allow him to use his logo when he is, and it's not just him, there's others that came to me, but it
He can list
allows
his
him to use
name.
his
He
logo.
can list his name as a sponsor, right?
I don't think he could even do that.
It's unclear, but they have logos which people recognize, and that's the idea
Right.
that they would be allowed to use their recognizable logo, which
It's
is
part of their branding.
It's part of their brand, yes.
I mean, for him, it's thousands and thousands of dollars that he contributes and he'd like to take credit for it.
Right.
Are we okay? Senator Reedy?
Thank you. Is there anything in this bill about the length of licenses? Is discussing the length of how long somebody has to keep a license before selling it? Would that be even germane to this bill at all?
That's not, it wouldn't be, wouldn't come from the commission. That's a policy call, and that's not in this bill about the length of licenses.
Okay. Is it?
Senator, it's something we're gonna look at next year as these other businesses have had the opportunity to get up and running.
Okay, we're looking at that.
We're gonna look at it
soon.
next year.
Yeah. Okay.
It's been discussed. I know where you're going.
Okay. Thank you very much.
Thank you.
Senator Washington.
Senator Washington?
I do have a follow-up, Madam Chair. Thank you for that. Just to follow up on Senator Reedy's question about the selling of a license. I've been trying to do my research and understand this industry more as I become new to the committee. And when I ran into some folks, they're really eager to purchase the social equity licenses after the 5-year moratorium and consolidate them at some point, and something that we should look at in the future. And I'm glad to hear that you say that we're going to look at that. So that's good to hear. In the bill, it does mention something about cannabis nursery. Is that a new license is that a best practice? What is that? And it does have in here like means a business that provides cannabis seeds, settling, immature plants, or clones. Is that we creating a new license here?
You're creating a new category of registrant, I believe, not a license, but they have to anybody who touches cannabis in the state has to be legally touches cannabis in the state has to be registered or licensed by the commission. So you're creating a new class of registrant for these nurseries.
So new businesses.
Yeah, new businesses, yes.
So this would be brand new business. So this is a substantive bill. So this is a new class of a business that we're creating to open opportunities for people to be able to, and they would just apply. What's the process for this? So would they apply through the commission, or
They would have to submit an application to commission. The commission, there's a whole process in here spelled out of how to become a registrant under the current law.
Madam Chair, I hope you will indulge me. I would like to read this bill a little bit more, if that's okay with you, and then if we can hold the bill just
We're
to
gonna
make sure
vote
that
again
we-
tomorrow morning.
Thank you. I
Thank you.
appreciate that.
We're gonna hold it till tomorrow.
Okay.
Cost to the registrant?
I'm assuming there is, yes. Anytime you pay for any type of license or registry, you have to pay the commission for that privilege.
Right. And so if Will, who's sitting in the back, could give us a idea of what registrations look like for its costs, how much are they paying?
Is Will sitting in the back?
Yeah.
Will, would you like to come up? We don't typically do this, but I think
I was just saying it out loud so he could get to us, but
I couldn't
you would
see
indulge
back
us, I'm
there.
good.
Obviously, I need distance glasses. So Will,
Hey.
can you talk to us about the nursery license, please?
Yes, Madam Chair. So it goes hand in hand with the clarification to the cannabis definition. What we saw in the interim were pop-up shops that were selling what they were claiming were seeds that were hemp seeds, in order to circumvent the law. And so there was significant concern in Baltimore City and other jurisdictions about this. And so the clarification of the definition makes express that it previously said all parts of the plant, which includes seeds. But we added seeds and clones to that expressly to make it super duper clear. And then separately, there is a registration, whereas right now only licensed growers, that limited number of growers would be able to sell seeds or clones. It would provide a new avenue. And the registration categories are not limited in statute and are usually a lower cost of entry. So it's to Senator Hayes's question, usually it's $100 for registrations versus the $1,000 for a micro application for a license and $5,000 for a standard. So significantly more affordable oftentimes.
So this new class of nursery is $100 registration.
If it was in, we haven't gotten there, it's not, hasn't passed through, but that's what every other registration is.
Okay. Senator Washington?
Is this similar in other states? Is this like a best practice to have this nursery?
Yeah, it has been developing over the past few years. A lot of the northeastern states, Massachusetts, New York, that have been sort of leading policy development in this area have added this nursery category.
And will this just apply to, as you said, there's people who are already doing it. Will this just apply to those folks, or will they obviously they have to come in and register, but could new folks come online?
Yes. Yeah.
Okay.
Yeah, so it's a new business opportunity.
I was going to say, Senator Washington, there's a new business opportunity for you.
I can't wait.
Do we have any other questions for Mr. Tilburg? Okay. Senator Hayes.
Well, you had mentioned the pop-ups and stuff that were popping around. Like, how prevalent is that happening?
With
Are we talking
the
one or
seeds,
two?
the seeds and clones, it was just a few.
Uh-huh.
I think you're familiar in your district with brick and mortar stores selling actual cannabis, intoxicating
Mhm.
cannabinoid products. That is happening with greater frequency. That happens as states legalize and criminal restrictions are reduced or eliminated.
Right.
And it's an important part of the other arm of this. We're the regulatory body that oversees the licensed businesses. There's also the Alcohol, Tobacco, Cannabis Commission that enforces against unlicensed operators. And so General Assembly was wise to do what other states had not and have a specific law enforcement group that can address unlicensed shops so that things are flowing through the regulated marketplace. There's a few that are in various points of investigation. Some have been, yes.
And so I guess as stated, we're starting a new business. Like right now we have a process where I think there's a couple of times a year where you could go for a license or whatever. Like, what would it take for me to do a registry? Are those available at a certain time, or is that an ongoing process?
It's rolling. So right now there are registration categories for independent testing lab, for secure transport. So that's business to business. It's not the
Right.
delivery to customers or patients that was discussed earlier. Waste disposal. And there's another one, but there's other categories that are not limited in statute and are not set application periods. There is a application for each that is up on Maryland One Stop, the centralized database for state registrations and license applications. You can go there now, pay the $100, submit criminal history information, business plan, and it's reviewed usually within 30 days and approved.
Gotcha. Thank you, Madam Chair.
Thank you. Do we still want to hold it? Okay, we're still going to hold it. We may have some phone calls before we
Yeah.
vote tomorrow.
All right.
You had a bill hearing.
We had a bill hearing.
Across the street doing other business.
Can't help that. Okay.
Right.
Okay, so you might want to just stay for the next bill. House Bill 272.
No, okay, House Bill 272 was heard yesterday, prohibits a person from applying for or holding a cannabis license or registration if the ownership interest in the license or registration is nominal or without the benefits and risks of genuine ownership or control, and for the limited purpose of satisfying the requirements for cannabis licensees or registrants including requirements for social equity licensees or registrants. Basically, you have to be legit to be a owner of a business, and this bill would make sure that all the owners of various licenses are legit folks who meet the requirements for licensure or registration under the bill, under the law.
Do I have a motion?
Favorable.
Second.
We have a favorable with Senator Classmeyer, second with Senator Gao, all in favor of House Bill 272. Have a unanimous vote. Will, thank you.
Okay, the next bill is House Bill 328. You have a reprint in front of you first. The bill modifies the required components of acute care and chronic care hospital financial assistance policies by prohibiting hospitals from considering household monetary assets as the bill came across from the House, assets in determining eligibility for free and reduced cost care, and removing the requirement that provisions of reduced cost care or payment plans be in accordance with the mission and service area of the hospital. You have a reprint in front of you with an amendment from the chair, which if you go to page 2, you'll see that instead of having all assets not counted, it would say a hospital may consider only household monetary assets in excess of $100,000 when they're determining eligibility for free or reduced cost care.
Do I have a motion favorable?
Move favorable.
Do I have a second? Do we have a second?
Second.
You're favorable. I need a second.
No, I'm.
You can't be the motion and the second.
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 Okay, Senator Classmeyer and Senator Kramer. All right, do we have questions on House Bill? Senator Ellis?
Yeah, thank you, I'm sure. So I got text messages from healthcare folks saying, especially units, they don't want amendments like that. And so
When you say healthcare folks, hospitals or other?
union,
Okay,
yes, and
okay.
I'm not sure the implications of that,
Okay,
100,000.
I actually
requires-
requested this and I'll tell you why.
Oh, please, thank you,
Okay.
thank you.
So, people have a limited income. They could be on Social Security and getting $600 or $700 a month. And looking at that alone, you would say, well, they shouldn't have to pay their hospital bill. Then you find out they have a couple $100,000 in an IRA or an annuity or some other savings, and they really could have paid their hospital bill, but they've got this money stashed away because the bill initially excluded assets. Now, it's not their home or their car, it's savings. So if they have 100,000 or less, it's not included. If they have more than 100,000, it's going to be considered in their eligibility to pay.
So that amendment says just liquid assets, cash in the bank, doesn't include
I want to double check. If
asset,
that's what it said.
doesn't include equity in home.
No,
It's not specified. It just says the hospital may consider only household monetary assets in excess of $100,000.
monetary assets.
Monetary assets in
Mon-
excess of, yes.
So that does not include home equity.
No,
Okay,
monetary assets.
yeah, okay. Just
Yeah,
making
nobody
sure.
has to sell their house to pay their hospital bill.
Okay, I'll get an appraisal.
Right.
Also, okay, thank you, ma'am.
You're
Chair.
welcome.
Appreciate it.
Senator Reedy?
So, I think this is good because, I had some concerns about the issue you're trying to talk about. So if it's monetary assets at excess of $100,000, it's also correct that even if someone has monetary assets above that and they have some astronomical hospital bill, they could still get some help. It's just saying they might have to pay a little more towards it than someone who might be destitute that might have the fund cover all their
Yes.
bills, correct?
It's
It would be
it's
considered.
authorizing.
It'd be weighed in, so that generally hospitals, I would imagine, try to they don't want to charge somebody so much that they don't get the money anyway. So they're going to try to work with them, but this at least gives us a little bit of a floor. Wonderful. I think it's a good amendment.
Thank you. Senator Lamb?
Would this include IRAs? Like someone's,
Whatever is called.
Monetary asset.
because I'm looking at the Attorney General's office had submitted, I guess, a follow-up letter where they say that the OAG supports removing removing asset tests from financial assistance policies in all hospitals, as research has shown that overly restrictive asset limits penalize savings, harm retirees who are relying on their assets in retirement, and are counterproductive to maintaining economic security for low-income families. So I guess this amendment just gives me concern that it actually,
Change their position. They initially. had.
yeah, they changed their position from the.
Yeah, they
original
changed their position as the
Yeah.
house, as the bill moved through the
I
House.
haven't seen that letter.
Yeah. So this is different than their initial position.
Mhm. Let's hold it, okay?
Okay.
We'll work on it.
OAG, the AG's office.
No.
No, on this specific provision, they don't support including an asset test. And they submitted a follow-up letter saying that.
But they didn't used to have that.
They didn't used to have that in their, I think they didn't used to have that in their letter, or it was different, but now they have submitted a new letter saying that.
Because the bill moved out,
All right,
yes.
so we're gonna hold the bill.
Okay.
House Bill 461.
Hey, this one, I can't get any easier. House Bill 461 renames the State Advisory Council on Quality of Care at the End of Life as the State Advisory Council on Serious Illness Care. That's all it
Move
does.
favorable.
Second.
Everybody woke up. I'm sorry.
I feel this way that you felt about the Maryland Ireland.
What they want.
Workers. Task force.
Commission wants the name.
Okay, all right. I guess they don't want to admit it's into life. Seriously,
It's quite a mouthful.
well, that's fair.
Why would I mean
Yeah, they're existing. If you want to see what their charges are, go to the last page of the bill and it tells you what.
It's just changed the name.
All right.
League. Yeah.
All right, so on House Bill 461, we have a motion, a second, all in favor? It's a unanimous vote.
Good song.
Okay, the next bill is House Bill 465. I believe I've got that right. Yes, 465. This was held from the other day. You have a reprint in front of you. There was one of the suggestions was to bring back the clear and convincing standard. But the sponsor of the Senate bill has additional changes and is proposing, if you look at the reprint, that it does increase the penalty for the civil penalty for multiple violations to $30,000, consistent with the Senate bill, but it leaves all the referral entities intact as it came over from the House and the Senate bill is introduced. So clear and convincing is still there, and all the entities that can receive referrals based on a violation of certain tax laws are still in the bill.
Senator Riles, is this the meeting we had this morning?
Yes, Madam Chair.
I'd like to hold the bill.
Okay,
One more discussion.
okay.
All right, again. Getting there. House Bill 602 was, this was heard the other day. It expands the state's equal pay for equal work law by prohibiting employment discrimination on the basis of sexual orientation. Under current law, it's discrimination applies to by sex or gender identity. The bill incorporates the prohibition of discrimination on the basis of sexual orientation into existing prohibitions for workplace discrimination under that law. These protections apply to payment of different wages based on sexual orientation in addition to sex and gender identity, providing less favorable employment opportunities based on sexual orientation in addition to sex and gender identity. Differing wages are allowed based on non-discriminatory seniority and merit systems under current law. The bill addresses a recent Maryland Supreme Court case that specifically referenced the absence of sexual orientation and the requirements and prohibitions under the state equal pay for equal work law.
have a motion?
Move
Favorable.
Favorable.
A second? Can I have a second? Senator Giles, second. All in favor of House Bill 602, the speaker's bill? 10-0.
Real subtle.
Okay. House Bill 609 is is a bill that extends collective bargaining rights to selected library systems across the state. I'll briefly summarize what's in the bill. It's a multi-page bill. It authorizes collective bargaining for employees of libraries across the state, except for library employees in Montgomery, Prince George's, and Baltimore counties, because they already have collective bargaining under separate laws. The bill establishes 2 bargaining units for employees and supervisory employees. And any existing agreements are maintained in the law until they're up and they have to renegotiate them. Some of you who are in Baltimore County may be familiar with this bill because it's very similar to the law that was passed several years ago for Baltimore County libraries. It has elections, provisions, bargaining topics. There's no binding arbitration regarding, the House amended out binding arbitration regarding disciplinary appeals and adverse personnel actions, and makes that authorizing. The bill clarifies which governing body for each library as by adding the words applicable. And I think there's going to be an additional amendment offered from the chair to change governing body to funding body to make it more consistent with what happens, at least in Baltimore City. There's also impasse provisions, which include the selection of a mediator, but if you make the change, the governing or funding body will not be bound by any of the mediator's recommendations. The employer, however, is required to approve the findings that do not require an appropriation from a mediator in the event of impasse. The agreement, again, as I mentioned, may include provisions for arbitration of disciplinary actions, and strikes, work stoppages, and lockouts are prohibited.
It changes one word. I was going to ask, it's a technical amendment that changes the word governing to funding body. If that's okay, that we can do that verbally? Okay. Are we clear on that? All right. Do we have a motion? And a second? All right.
Senator Mouse.
Uh-huh.
And that amendment, can David explain why that amendment is important again?
Sure.
It's, and my understanding is, at least in Baltimore City,
Right.
by calling it a governing body, that may conflict with the law that concerns Enoch Pratt, where it says that that specifies the role of the city, and it may create a conflict. So it's more clear to just say funding entity, because that's really what you're talking about here. The entity that provides all these entities that provide applicable funding entities for the for all the libraries, which are all the counties.
Gotcha. Thanks.
In most cases, it is the governing body.
It
but
is, in
not
most cases,
always.
it is the governing body, but
See.
it creates that particular term creates a conflict with Baltimore City and how they're with their responsibilities for the Enoch Pratt Library.
And Senator Mounts?
So the funding entity, would they be opting into this, or this is going to?
It just changes the reference from governing body. There's no opt-in. The funding entity still retains all the rights they have. The governing body or funding entity still retains all their rights to determine the budget of a library system. Doesn't change any of that. So they're not really opting in. They're just part of the process when it comes to, and if there is collective bargaining, if they vote for representation and they vote and they negotiate, they come up with an agreement, then it's up to the funding entity, if there's anything in there that requires appropriation, to decide whether they want to fund that or not. If they say no, then it goes back to bargaining and they have to come up with it goes back to bargaining and have to renegotiate that part of the agreement.
Okay, thank you.
We have a motion and a second. All in favor? Okay. Roll call.
House Bill 609 favorable with amendment. Vice Chair Klausmeyer.
Yes.
Yes. Senator Kramer.
Yes.
Yes. Senator Hayes.
Yes.
Yes. Senator Reedy.
I'd like to abstain.
Abstain.
What?
Senator Ellis. Are you a librarian? You said Senator Mouts, no. Senator Washington.
Yes.
Yes. Senator Guile.
Yes.
Yes. Senator Lamb.
Yes.
Yes. Senator,
You can vote
Oh.
Senator Reedy, no. Senator Ellis.
Yes.
Yes. Madam Chair.
Yes,
Yes.
And there's a cross file. Senator Lamb has the cross file, Senate Bill 591, so you could vote to conform 591 to be identical to House Bill 609. I know the amendment's already drafted, so it's ready to,
So moved.
Second.
with that one change. You have to make that one change, but it's conforming.
do we need to vote again?
I think it's same vote.
Okay, same vote.
And this still this has to go to triple E too,
Okay.
so.
Okay. House Bill 676.
Okay. A couple years ago, you passed a bill called Right to Try. This is modifies that bill. It's House Bill 676. It modifies the Right to Try Act by repealing the definition of investigational drug, biologic product, or device and replaces references to that term with individualized investigational treatment. That's pretty much the main change in the bill. The bill further specifies that a manufacturer operating within a facility may provide an individualized investigational treatment to a patient without compensation or charge the patient for the cost or associated with the manufacturers of the treatment. Carriers or government agencies may provide coverage for the cost, but they're not required to for investigational treatment or related services. A hospital or another healthcare facility is not required to provide new or additional services unless approved by the hospital so there's no requirement on any healthcare facility to provide these services, and there's no requirement that any carrier or third party pay for these services.
Move favorable.
Second.
All in favor of House Bill 676? We need to call. Okay. Unanimous vote. Thank you.
Asked every. Okay, House Bill 723. This is from the Office of the Attorney General. It authorizes the Attorney General to prevent irreparable harm to residents to seek injunctive relief on behalf of the state on the basis of an imminent or ongoing violation of a specified basic right of residents of a nursing home or assisted living program. The Attorney General, and this was as the bill was altered in the House, the Attorney General may not duplicate corrective action imposed by the Maryland Department of Health for the same violation. The bill also alters the definition of resident bill of rights for residents of assisted living program facilities. The House worked on this bill. There was some opposition, and as the House amended the bill, there is no opposition to the bill.
Move favorable.
Second. All in favor? 723.
Mhm.
Okay. Call the roll.
House Bill 723, Vice Chair Klaus Meyer. Yes. Senator Kramer.
Yeah.
Yes. Senator Hayes. Yes. Senator Reedy. No. Senator Ellis.
Yes.
Yes. Senator Mouts.
No.
No. Senator Washington.
Yes.
Yes. Senator Guile. Yes. Senator Lamb.
Yes.
Yes. Madam Chair.
Yes.
Yes. 8-2.
Okay, House Bill 805 is the cross file to Senator Feldman's Senate Bill 537. And you have a reprint in front of you. The bill House Bill as amended is now in the same will be in the same posture with this reprint as the Senate bill that passed out of the Senate. There is a slight tweak to the amendments, and if you go to page a slight addition here, if you go to page 4 of 6 of the reprint, the bill as it crossed over had to deal with agricultural, the ability to grow outdoors. So a political subdivision, and this language came from MML, a political subdivision may not adopt an ordinance establishing the zoning requirements for a licensed grower cultivating cannabis exclusively outdoors in an area zoned for agricultural use. That was in the bill that came across. It has an additional protection for groups that were previously authorized outdoor grow prior to the legalization of adult use cannabis. And it prohibits them from losing that ability by any subsequent action by a jurisdiction. So it preserves the right, like with everybody else, you preserve their existing right. They had rights up until they had certain rights, and it preserves those rights as of the legalization. So if a group was authorized to grow outdoors cannabis prior to legalization, they would still maintain that ability going forward. Senator Philman. And otherwise, the bill is in the same posture as the Senate bill that left the Senate. Whatever the Senate did, the Senator Philman's bill has been amended into this bill. Yeah, everything is in there.
Okay.
And you also, it struck the House bill came over with language about the Senator McCray bill. It strikes that out of there because you have a separate bill over in the and that bill is still alive in the the House added Senator McCray's bill to their bill. This takes that out because you have Senator McCray's bill as a standalone bill over there.
Yeah, thank you, Mr. Chair. I'm trying to have some clarity here. I thought we dealt with a House bill on the Senate floor, deal with locations. So this bill, is this the bill that talks about the zoning and has the amendment on from the Prince George's County Senator?
Yeah, this is the House bill. You dealt with that on a Senate bill. This is the House bill, and it's now amended to look like the Senate bill with that additional protection for licensees who had the ability to grow outdoors prior to legalization.
Okay, great. Thank you. Yeah.
All right, so I think we had a motion and a second. Okay, Senator Klausmeyer motion. Do I have a second? Senator Ellis seconded. All in favor of House Bill 805? Okay, I think we need to call the roll.
House Bill 805, favorable, Vice Chair Klausmeyer.
Yes.
Yes, Senator Kramer. Yes, Senator Hayes.
They're talking to the speaker.
So when we accepted those amendments to the Senate bill, I wasn't even on the floor. I didn't realize it went by so fast. I know I would have probably raised some objections at the time. And it sounds like this bill has incorporated those amendments. So for right now, I'm just, until I look at it a little bit closer, I'm gonna vote no.
Okay.
Senator Reedy.
No.
No. Senator Ellis.
Yes.
Yes. Senator Mounts.
No.
No. Senator Washington.
In explaining my vote, I appreciate the amendment because it does provide some buffer and ensures that we don't have a saturation of these licenses throughout certain counties and inside the beltways and in older, more established poor communities. And so I vote yes.
Thank you. Senator Gao.
Senator Guile.
Yes.
Yes. Senator Lamb.
Yes.
Yes. Madam Chair.
Yes.
Yes. 7-3.
Okay.
Okay, I promise you only be here for another 2 hours.
You have all the controversy.
House Bill 871. This is really, this requires a licensed automotive dismantler, scrap metal processor, or junk dealer that acquires all or part of a detached catalytic converter to record and keep in the person's records, the person who sold the catalytic converter or who the scrap or dismantler bought it from, record the vehicle identification number of the vehicle from which the catalytic converter was obtained. This is a lot, as you heard in the testimony, this is a lot of law enforcement officers to better track, particularly from dismantlers, stolen catalytic converters.
It's a whole industry.
It's a whole, yeah.
Favorable. Second. I've had my catalytic converter stolen.
A lot of people have.
One of my delegates has had hers stolen as well. Yeah.
We had a motion and a second. All in favor of House Bill 871?
Yeah.
Yep. Okay. All in favor.
Despite it hurting the mom and pop jokers.
Okay, the next bill was heard yesterday. This is House Bill 969, and it establishes a process if the cause or manner of death on a death certificate is amended or corrected by the medical examiner. If the cause or manner of death is amended or corrected or determined to be a homicide, the medical examiner must notify the state's attorney and local law enforcement where the body was found. Next, the medical examiner must also request that the Secretary of Health send a person in interest, which is usually a family member, a new certified death certificate at no cost. The assistant state's attorney must meet with the person of interest regarding their request regarding it, opening up a new investigation into the circumstances of the victim's death. Finally, a law enforcement agency upon notification must reopen or reinvestigate an investigation involving the death of a victim and keep the case open for at least 20 years after being notified. So if the cause of death is altered by the medical examiner, then this process takes place to allow possibly the case to stay open for 20 years if it's ruled a homicide or what was the other possibility here? Or well, it's that I think that's the underlying.
That's what it's all about.
Yeah, so it's what it's all about. So
Reclassification.
if the cause of death is reclassified by the medical examiner, then this process kicks in.
Okay.
So we had a motion from Senator Classmeyer. Is that a second? Yes. Senator Reed, second. All in favor of House Bill 965. Okay, Senator Hayes? Okay, unanimous vote. All right, stay with me. We got 3 more bills.
Fading quickly, Madam Chair.
I know, I already faded.
Okay, the next bill is House Bill 1122. It's the nursing home acquisition bill. It was asked to be held because Senator Ellis has an amendment, and it's a pretty comprehensive amendment. I have copies here. The amendment isn't exactly, I think it creates duplicate processes. So I don't know if we want to work on your amendment, or do you want to take up the bill, or what would you like to do, Senator?
Yeah, thank you, David. I appreciate you working with me with this. So from early in the session, we had a briefing from the Maryland Health Care Commission, and brought this issue on the transfer of nonprofit nursing homes, and they're problematic. And even all this week working on these amendments, and the final amendments just came from the reviewer's amendment office like 30 minutes ago, and you haven't had a chance to look at it. So could we hold the bill until tomorrow morning, Madam Chair? Because
I do have some information too, on an income tax law that we can talk about.
Okay.
We can hold it till tomorrow.
Yeah,
That's
thank
fine.
you.
Okay. I'll have it ready for tomorrow morning.
Well, we might hold it till Tuesday, because we'll vote again Tuesday, but we'll see how the schedule looks tomorrow.
Because I think your amendment needs a bit of work, because it creates a lot of, I know what you did. You brought in a section of another law, and there's a lot of duplication, and it duplicates some processes that already exist. So
we can, well,
okay.
Okay.
All right. Where are we?
House Bill 1229.
1229. Okay, this is House Bill 1229. If you recall from yesterday, requires a retailer that prepares, distributes, and sells or exposes for sale a Kratom product to disclose on the product label a lot of information, including that it doesn't meet FDA requirements or it is not consistent as a supplement. The bill also limits the use of Kratom as an ingredient. Retailers are prohibited from distributing, selling, or exposing for sale a Kratom product to an individual younger than 21.
Second. No, I can't second. Second.
It's a tropical tree native to Southeast Asia. Consumptions of its leaves produce both stimulant effects in low doses and sedative effects in high doses.
Okay, we have a motion and a second. All in favor of House Bill 1229? Okay, unanimous vote? Okay, thank you.
Okay.
Last bill.
And related to the bill you just heard, instead of a House Bill 1230, instead of limiting the sale to adults of this teneptin product, it prohibits the retail sale in the state of Maryland of a teneptin product. Violators of the ban may be guilty of a misdemeanor and subject to a fine of up to $5,000 and imprisonment. It's an unapproved drug in the U.S., although other countries have approved this drug to treat depression and anxiety, and some people have turned to tineptine as an opioid alternative, but it's not an opioid. And as you heard from testimony, naloxone will not work in the case of an overdose because it's not an opioid.
Sold right now.
You can buy it right now. This would prohibit the sale of it. It's got a nickname, gas station heroin.
Oh, wow.
All in favor of House Bill 1230? Unanimous vote on House Bill 1230. Thank you. We did that.
I'm sorry. We have, this will be very quick. We have some concurrences. The first one is Senate Bill 613. You just passed the House bill in the same format. The bill extends the implementation of regulations of assisted living program managers. The House amended the bill with the same clarifying amendment that you added to the House bill. So you would want to concur, so the bills are identical.
All in favor of the concurrence on Senate Bill 613?
And you have to sign.
Unanimous, thank you.
Oh, she doesn't need to sign? Never
Good.
mind. Everybody changes. The next concurrence is on Senate Bill 197. This is the bill that deals with the misclassification of personal care workers. The difference between the House and the Senate bills is the title. So the House amended the bill to add Home Care Worker Rights Protection Act of 2024. So that would mean both bills are identical.
Second, all in favor of the concurrence? Thank you. All good.
House Bill 1451, because we wasn't clear what action the House had taken. They did not adopt the new name on the Senate bill. They left the Senate bill as is.
Okay,
And so if we could go ahead and move that in the same posture, it just hasn't popped up on the screen yet.
okay, so you're suggesting we move 1451 in the same posture as
That
Senate
the
Bill
Senate-
764?
Yeah.
Pardon me? Okay. Favorable with amendment on 1451.
Yes, ma'am.
All in favor? So we retreat back to the old title.
Yes, ma'am.
Thank you very much.
Yes, ma'am.
Okay. All right, thank you.
So when are we voting for?
We are voting at 9 tomorrow. We'll get as much done as we can before the floor. And then we'll see if we're gonna come back after the floor. Well, it's right, because then we can't vote again till Tuesday. And they go on the floor Wednesday and get voted Friday. Now we're getting a little close. So if you don't mind, we're gonna get as much done as we can tomorrow and then Tuesday. Finish up we have one bill hearing on Tuesday. That's all we have for bill hearings next week. 9 a.m. I just had to move a whole bunch of people. 9 o'clock. Thank you.